First, welcome to the video. Today we will unpack why I-485 applications are denied when a minor has overstayed, how the petitioner's status as a lawful permanent resident versus a U.S. citizen changes eligibility, and why leaving before turning 18 can be crucial. We will also discuss consular processing, timelines, the F2A backlog, the Visa Bulletin, CSPA considerations, and the potential benefits and risks of a parent naturalizing. Finally, we will conclude with key action items and a quick knowledge check. Let's begin. Next, here is our roadmap. We will start with the basics behind I-485 denials when there is an overstay and the petitioner is a lawful permanent resident. We will contrast this with the immediate relative exception available to certain family members of U.S. citizens. After that, we will explain the under 18 unlawful presence rules and why timing a departure before the 18th birthday can avoid 3-year and 10-year bars. Moving forward, we will outline consular processing steps, discuss F2A backlogs and priority dates, and explain how the petitioner's naturalization can change the category. Finally, we will end with a practical checklist and a recap. Before we dive deeper, a brief but essential disclaimer. The information provided here is for educational purposes only and does not constitute legal advice. Immigration law is complex and very fact-specific. You should consult an experienced immigration attorney to receive guidance tailored to your circumstances, especially regarding departure timing, consular processing strategy, and CSPA or Visa Bulletin nuances. Now let's lay the groundwork. Adjustment of status typically requires that the applicant maintain lawful status while inside the United States. If someone overstays a B2 or other non-immigrant visa, they generally become ineligible to adjust status domestically. There is a major exception. Immediate relatives of U.S. citizens, such as a spouse, a minor child, or a parent, often can adjust status even after an overstay. However, this exception does not apply to children of lawful permanent residents. Children of LPRs fall under the F2A preference category, which requires strict compliance with the terms of admission. Therefore, if an overstay occurred, even by a short time, an I-485 in the F2A context is correctly denied. Continuing, it is crucial to distinguish between LPR and U.S. citizen petitioners. With an LPR petitioner, the child is categorized under F2A, which is a preference category. This requires the applicant to be in lawful status to adjust. Any overstay will lead to I-485 denial. In contrast, for a U.S. citizen petitioner, a minor child qualifies as an immediate relative. In that category, overstays are often forgiven for purposes of adjustment of status, which means the applicant can typically adjust inside the United States. Furthermore, immediate relative categories generally have no quota backlog, whereas preference categories may face waiting periods. Next, observe the decision map. After a lawful entry, the first key fork is whether there was an overstay. If not, the applicant can maintain status and pursue adjustment when eligible. If there was an overstay, we branch by petitioner type. For a U.S. citizen petitioner, the minor child is typically an immediate relative, and overstay is often forgiven for adjustment of status. For an LPR petitioner, however, the I-485 is denied due to the overstay. From there, we check age. If the person is still under 18, they can depart before 18 to avoid triggering the 3-year or 10-year bars on departure. If they are 18 or older and out of status, unlawful presence begins accruing, creating bar risks at 180 days and 365 days. The under 18 exit route flows into consular processing abroad, with a note about F2A backlogs and the need to monitor the Visa Bulletin. Meanwhile, let's clarify unlawful presence. Under immigration law, children under 18 do not accrue unlawful presence for the purpose of the 3-year or 10-year reentry bars. This means that if they leave the United States before their 18th birthday, they can typically avoid triggering those bars. However, once they turn 18 and remain out of status, unlawful presence starts accruing immediately. Accruing 180 days of unlawful presence results in a 3-year bar upon departure, and accruing 365 days leads to a 10-year bar upon departure. The strategic takeaway is to plan an organized and timely departure before turning 18 to preserve eligibility for consular processing without needing complicated waivers. Next, examine the age and bar timeline. From entry through the day before the 18th birthday, there is no unlawful presence accrual for bar purposes. On the 18th birthday, if the person remains out of status, unlawful presence begins to accumulate. At approximately 180 days after turning 18, the 3-year bar risk is reached, and at about 365 days after turning 18, the 10-year bar risk arises. This visualization underscores the urgency of planning the departure before turning 18. Furthermore, let's walk through consular processing. First, verify that the I-130 is approved under F2A and identify the priority dates. Second, monitor the Visa Bulletin each month until the priority date becomes current. Third, plan the departure before the 18th birthday to avoid triggering bars. Fourth, begin the National Visa Center process, including paying fees, completing the DS-260, and submitting civil documents. Fifth, prepare and submit the I-864 Affidavit of Support with appropriate financial evidence. Sixth, attend a medical exam with a panel physician. Seventh, go to the consular interview abroad, bringing the required original and copy documents. Eighth, if approved, receive the immigrant visa, enter the United States as a permanent resident, and pay the immigrant fee. Finally, watch for the green card to arrive and follow any post-entry guidance. Now, compare the F2A waiting window against the age clock. The Gantt chart shows the visa queue steps waiting for the priority date to become current, the NVC processing stage, and interview scheduling stacked against the individual's age milestones. The overlap reveals the core risk. The queue may extend while the person approaches age 18. A timely departure before turning 18, paired with careful tracking of the Visa Bulletin and NVC tasks, helps maintain eligibility without triggering reentry bars. In addition, consider CSPA and aging out. Because F2A is a preference category, backlogs can delay visa availability. The Child Status Protection Act may help preserve a beneficiary's classification as a child in some scenarios, but the calculations and seek to acquire requirements are technical. Timing is critical. Work closely with an attorney to determine when to act, how to preserve eligibility, and how any category conversion may alter requirements. The overall goal is to avoid aging out by turning 21, while still maintaining a viable path. Moreover, if the LPR parent naturalizes, the underlying petition may convert to the immediate relative category, which can significantly improve processing by removing quota backlogs. This change can impact consular processing steps and eligibility options. Still, timing remains critical. If conversion occurs too late, aging out risks may remain. Accordingly, consult qualified counsel to determine whether pursuing naturalization now offers a better outcome than remaining in F2A. To summarize key deadlines, under 18 is the optimal window to depart and avoid reentry bars. On turning 18 while out of status, unlawful presence starts accruing, creating 3- and 10-year bar risks at 180 and 365 days. While the priority date is not current, monitor the Visa Bulletin and prepare the NVC packet to minimize delay. If the parent naturalizes, the petition may convert to the immediate relative category, potentially speeding up processing, though timing is crucial. As the beneficiary nears 21, evaluate CSPA options and consider steps to prevent aging out. Now, a quick knowledge check. Which group generally has an overstay forgiveness path for adjustment of status inside the United States? Option A, children of LPRs in F2A. Option B, immediate relatives of U.S. citizens. Option C, all employment-based applicants. Or Option D, diversity visa selectees. You may pause the video now to think about the answer. We will discuss the correct answer in the next section. The correct answer is B. Immediate relatives of U.S. citizens. Immediate relatives often have an overstay forgiveness path for adjustment of status, unlike applicants in the F2A preference category. Here's another quick question. To avoid triggering the 3-year or 10-year reentry bars, what should an overstay minor do? Option A, wait until after turning 18 to depart. Option B, depart the United States before their 18th birthday. Option C, file a new I-485 while overstaying. Or, Option D, ignore timelines and focus only on the interview. You may pause the video now to think about the answer. We will reveal the correct answer in the next section. The correct answer is B. Depart the United States before the 18th birthday. Leaving before turning 18 prevents the 3-year and 10-year unlawful presence bars from being triggered when departing. Finally, consider the most common pitfalls. The pie chart illustrates 4 key issues. Waiting past the 18th birthday, assuming that an LPR petitioner offers the same overstay forgiveness as a U.S. citizen petitioner, neglecting to track the Visa Bulletin, and attempting a do-it-yourself approach without professional guidance. Being aware of these pitfalls helps families plan decisively and avoid costly mistakes. As a practical takeaway, follow this checklist. Confirm the I-130 approval and record the priority date. Track the Visa Bulletin each month. Plan a departure before age 18 to avoid bars. Complete the DS-260 and upload civil documents to the National Visa Center. Prepare a complete I-864 with financial evidence. Schedule and attend the medical exam, and organize original and copy documents for the interview. Importantly, consult an experienced immigration attorney early. Finally, evaluate whether the parent's naturalization would improve timelines and outcomes. To wrap up, overstay combined with an LPR petitioner usually leads to an I-485 denial in the F2A context. However, minors have a crucial advantage. Leaving before turning 18 generally avoids the 3 and 10-year bars. Consular processing becomes the main pathway, and success depends on careful timing, ongoing tracking of the Visa Bulletin, awareness of CSPA considerations, and guarding against aging out. If the parent naturalizes, the case may improve, but timing still governs strategy. Above all, engage a qualified immigration attorney to craft and execute the plan. As we conclude, thank you for watching. If this video helped you understand the path forward, please like, share, and subscribe. In the comments, tell us your questions and your experiences. Your story may help another family navigate this process. See you in the next video.